Okay. So this is somewhat rudimentary PowerPoint, but bear with me. This project looks at the nature of the idea of rivalry or rivalrousness and its opposite, non-rivalrousness, in property and intellectual property law and the role that's played there. And the starting point in all this, for me, is the basic conceit, at least since the advent of legal realism, that property law is all about resource conflicts. That's what we have property for. Two people want to eat an apple. They cannot both do it. That would be disgusting. And so we have to have some system to mediate between them, and that's what property does. Within that, there are better and worse ways to select who prevails. The very first issue that comes up is who wins in that conflict. The conflict is grounded in the, as it were, in the nature of things, in the fact that we get these conflicts, and those conflicts arise out of the inability of goods to satisfy the competing demands that are made upon them by different people seeking to use them. So, in a sense, or in a nutshell, is that two people can't use the same good at the same time, something like that, or one person's use interferes with use by another, and that basic problem lies at the root of property law. In this sense, property is grounded in the rival property of goods, which is also linked maybe more traditionally with the idea of scarcity. Rivalry itself is a term that's taken from the public goods literature, developed in the second part of the 20th century, and there the real interest is with the nature of its absence of non-rivalry. So here's a kind of standard definition from the economic literature, where a unit of a good can be consumed by one individual without detracting from the consumption opportunities to someone else for the same unit. So that's something like that is the idea that's at work, but there's a very basic similarity there with this more general and sort of conceptual sense that we have goods that can't be used by two people, that one person's use interferes with another. Why does non-rivalrousness matter in the public goods economics literature? I'm not going to dwell on that at great length. My primary focus is on the more kind of conceptual end of things, but just there are some arguments that suggest non-rivalrousness supports the creation, or can support the creation of exclusive rights. I think there's maybe some reasons to question those arguments. I'm more focused on the second argument, which is a kind of, or a set of arguments, which is a critique of exclusive rights, or at least a principle of limitation. And the problem is that because when we think of non-rivalrousness in economic terms as a situation in which producing the good to an additional user can be done at a marginal cost of zero, allowing a price higher than that to be charged is necessarily going to result in a deadweight loss. This is a static view of things. It doesn't. This sort of assumes the good already exists, but that's maybe okay. The point of making this argument, I think, is to bring us back to where we started on the conceptual side of things. The point is that exclusion has costs. So it may be that it's justified as a sort of a kind of a subsidy or an incentive or spur to development, but there's something that's given up in foreclosing access to something by others. And so that static view, what it does essentially is to isolate, to set aside the incentive side of things and show what's left. So the more general claim, which I think is related to that, is that if we have property because goods are rival, property rights themselves are sort of rivalrous in a way. They're sort of exclusive rights, and it only makes sense to have exclusive rights for those things that have to be used exclusively. If multiple people can use the same thing without interfering with one another, it doesn't make sense to have exclusive rights that close off access. And the implication is that IP is, in a sense, is in a suspect or defensive posture because it closes off access without a kind of without the intrinsic need for it that you have with rivalrous goods. Because the basic feature of intellectual goods is that they can be used by more than one person without causing this decreased ability to derive benefits from them. So that's the sort of starting point for all this, and it's my primary emphasis is on this kind of rhetorical side of things, in the sense that something's a little fishy there. So one thing I want to drill down a little bit more on what it means to say that goods are non-rival and what rivalrousness consists in. The first thing is that though we often speak in categorical terms, or the literature speaks in categorical terms about goods, this is a rival good, non-rival. In fact, things are more variable than that in a couple different ways. To give an example, some roots in history, a stream, when used for motive power to turn a mill wheel, as was the case in, say, 18th century New England, is non-rival as between different mill owners, to the extent that one person's use of the flow of the stream to turn the wheel and spin the millstone doesn't detract from some other mill's ability to do this. So that's a sort of those uses are not rivalous against each other. On the other hand, when the stream is being used as became more common and as with Western expansion, when the stream is used to irrigate crops, suddenly we're faced with a rivalry problem because diverting water out into the field makes less water available for others who are downstream who would do the same. And so the nature of rivalrousness changes. It changes. It's not just a sort of monolithic feature of the good. And this has been, I should say also, it's in the economic literature, it's recognized very widely that sort of pure public goods seldom, if ever, actually occur in the world. I'm making a slightly different point here, insofar as at least the focus is on things like congestion, externalities, and things like that. I'm setting those problems aside and focusing more just on the choice between different uses. Some uses are incompatible and other uses aren't. The other thing is that these features are contingent. It depends upon what it is people want to do with the good. So the good has certain intrinsic features to itself, but ultimately the problem of rivalry arises when the plans that individual people have for the good are incompatible with each other, when those tastes and desires change, when the stream is no longer going to be used for mill purposes but for irrigation purposes, then rivalry comes out. So there's a sense in which it's dependent upon what the preferences, attitudes, tastes, desires, however you want to put it, of different people are. So that's the first kind of major piece of groundwork I want to lay down. The second concerns the meaning of use, or what we might call interests in non-use as use. This gets a little bit semantic, and I don't want to get tangled up in that. The point that I want to make is, I hope, fairly straightforward. It's quite possible that resource conflicts can arise, not simply because A wants to use a good and B wants to use a good, and both of those uses cannot happen, but because A wants to use a good and B wants A not to use the good. And that's a conflict right there, irrespective of whether B is actually looking to use it him or herself. So think of something in land use law, think of conservation easement. I am opposed to the development of a luxury high-rise in pristine wetlands. These wetlands happen to be located on the opposite side of the world, in some place where I am unlikely ever to go, have no desire to go. I'm not looking to enter this parcel of land, look at it, view it. I'm just upset and offended to think that it might be developed, and I object to that. This is something that's quite real, and that property law in any number of situations responds to. Or similarly, suppose I have a vacant plot of land, I'm somewhat neglectful, I don't really have any great intentions for it, but someone wants to hold, let's say, a neo-Nazi rally on it. I oppose that, I object to it, and in fact, property law, if I'm the owner, will vindicate that. But the larger point is that the good can be thought of as rival in that sense, despite the fact that I'm not actually myself looking to do something with that land. Does this happen with IP? It certainly can. In fact, it happens with some frequency and perhaps more than we might expect. There's, it turns out, as they start digging into this, this is a marvelously rich history of rock stars objecting to the use of their songs by Republican presidential candidates ranging rock stars ranging from Bruce Springsteen to Orleans, authors of or performers of Still the One. Pharmaceutical companies don't want their products used for capital punishment. J.D. Salinger doesn't want his correspondence made public. Warner Brothers refuses to license Dukes of Hazzard cars, which have the Confederate flag on top. And then just think of the entire universe of speech regulation, whether in the form of whether privacy laws, blasphemy laws, all kinds of things like that. There are all sorts of occasions in which what people want is for someone else not to have access to a piece of information, an informational good, and so the conflict arises in that way. It's not the conflict arises simply because the one person is trying to use it and that use is incompatible with the others. This raises some questions that are to me interesting, but for which I have no answers, but I will just share them with you. Should we count in this calculus purely pecuniary interests? It does seem like a lot of property is held for its economic value. Think of every book in Barnes & Noble downstairs. Barnes & Noble, the corporation, is not looking to read them, but they nevertheless do not want anyone to cart them off. What do we do about this sort of exogeneity, endogeneity problem if it's the law itself that's generating these preferences because people have a sort of expectation that IP law or sort of cultural property more generally has given them? Do we count that as a source of as the kind of interest that would support rivalry? And to what extent should the law itself be invested in trying to shape preferences in order to reduce conflict, so that the need for resolving these problems goes away simply by making people kind of more sharing-minded and less cantankerous and objection-minded. Circling back then to the big question, IP is so frequently said to be non-rivalrous. What do we make of this claim? There are certain technical and narrow uses within which it's perfectly fine to say this. They depend on narrowing assumptions, which is that what we are talking about are just these affirmative uses. The example that sort of comes to mind is if you think about the lighthouse as the classic example of a public good. One shipping captain's use of the light emitted by the lighthouse doesn't detract from another's ability to do so, so we think of it as a non-rival good. Maybe it's not, however, quite so non-rivalrous when we think about the person who happens to be, unfortunately, to be living next to the lighthouse. And if that example isn't clear enough, think of a foghorn tooting away all night. There may be these interests that are external to a particular use, but once we leave those out and we say, well, we're not concerned about that, what we're trying to figure out is just how to deal with this problem of lighthouses, assuming we want them, then it can be meaningful. But that's not the general claim about the that gives rise to the sense of suspicion toward IP rights. That claim requires, I think, at least a prima facie, that we consider the possibility of these interests in other people's non-use. So, in that case, to say that IP is non-rival means one of two things. We're either making an empirical judgment, that in fact these interests don't arise all that frequently, that in fact people are sort of inclined to get along with each other and don't want to hold one another up for no reason, or even for light reasons, or else we're assuming that we're making a kind of normative judgment. The empirical assumption, I think, is harder to reach a priori from our armchairs than we might at first think, because the breadth of situations in which these kinds of interests arise really is quite substantial. On the normative side of things, the first thing is that this is not if we are making this normative judgment and saying, gosh, the law just doesn't exist to vindicate your desire to be a schmuck, or just get in people's way, or veto people's projects. The first thing to note is that we have not said that that's what's going on. This is meant, the analysis here is meant to be more positive. And the reasoning about this, why we reach these conclusions, is undisclosed. We sort of need to sort that out and bring that out into the open. I think it's quite plausible to say that at least some of these claims are not worthy of being upheld, but there's some work that has to be done there in any event. And I'm reminded, I sort of cited this in the abstract that's distributed, but Locke has this phrase about how the earth was not given to the quarrelsome and contentious, but to the industrious and laborious, and that's there's something out there. There is the basis for claim. That leads to the third problem, which is how do we figure out which are the good interests in pure exclusion and which are not? Because I think there are situations in which it does seem like we would say, well, if we believe in ownership generally, then there's no reason, for example, to exclude my interest in preventing the neo-Nazis from using my land from the calculus, but maybe there is good reason to exclude from consideration my mere cantankerousness. But figuring out where that line is drawn is sort of tricky. So that's the basic set of problems that are there. I think I'll stop, and I'm glad to hear your questions, objections, and critiques. Yes, please.
Well, I think there's some good intuitions here. I just wonder if, to some extent, excludability and rivalrousness are getting mixed in here together. It seems like sometimes we're really talking about excludability rather than rivalrousness. So when it comes to IP especially, especially with real goods, I take your point that non-rivalrousness up to a point, and therefore. But if we think of ideas or recreating a song or something, they're pretty, if not purely non-rival, pretty close to that. And all the cases you're getting into is people wanting to exclude others and have that right. And so I just wonder if we want to pull that apart a little more. Even the lighthouse example, and Coe's really went through and showed how lighthouses can be excludable goods, even though they're still non-rivals.
Yeah, no, by not excludability in the public goods literature, I take that to mean generally that it is technically difficult to some degree, and maybe a prohibitive degree. It's difficult to prevent someone from gaining access. The point that I'm making is that there are situations in which you wish, maybe it's easy to do, maybe it's hard to do, but what you wish is to bar someone else's access, or you just wish that you just want to deny them access to the resource in question, and that can be as true for informational goods as for tangible physical ones. Yeah, Dr. Brett.
So I was told that I had to attend this talk, my head would explode, and I'm glad my head's still on and didn't explode. But so I have various reservations, but one of them is, so I told you this earlier, it's not IP, it's the intellectual good or the intellectual resource in question. We're not talking about the intellectual property being non-violent. No one says that. When they do say that, they're making a mistake.
Right.
So the resources versus the property regime are two distinct things. In terms of the resources, look, there's a difference between the costs associated with my consumption right, which is the Kornson-Sandler definition, refers to the impact on the cost of consumption, essentially, other people's opportunity costs, or the cost of other people consuming the same thing. What are the marginal costs associated with that? The non-use stuff has more to do with third-party effects. It's one thing to say my consumption doesn't impact the capacity of the resource to service other people's consumption opportunities. It doesn't impact other people's consumption opportunities, and yet all kinds of speech harm others, have third-party effects, that if the other third party who's affected by my consumption, my generation of an idea, my sharing of an idea, whatever, they'd rather have me not say it, right? So it's true, it's absolutely the case that there's tons of conflict, or if I publish a PhD thesis and you are doing it independently somewhere else, and the constructed market for PhD theses only gives thesis to the second person, or the first person. It's true that my consumption of the ideas in the thesis about gravity or about whatever, right, have a preclusive effect on your use value, right? All of a sudden, you don't get the same value out of that idea. You can still consume it, though, at zero marginal cost. You can write about it, you can think about it, you can do certain things. There's a particular path to generate your value of writing a PhD thesis is shut down.
Yeah,
those are distinct things, and I think that in the economics literature, these things are completely understood as being separate. And so I think you're kind of forcing the use value into the consumption cost issue. And I mean, I don't know, I just feel like doing that ends up sort of conflating something quite important.
So,
I don't know that necessarily change where you end up about intellectual property, though, by the way. I think it ends up.
Yes, so on intellectual property as non-rival, it's right. It's just easier to say IP, but of course I mean the underlying ideational resource. In terms of the value, I actually have some doubts about the line that's drawn, or at least it's quite possible that when it's drawn with physical things, it's drawn in a somewhat arbitrary way. But leaving that aside, my point,
Which line are you talking about? Pardon? Which line are you talking about?
The line between value and use.
Oh.
My argument is not that in some situation someone else's value will be diminished. I mention that only because it's a motivation that explains why they might have this interest. All I want to say is that there's a range of situations in which B wants A not to make use of the informational good, and it's not, maybe it's because it diminishes the value that can be extracted from the other person's use. My point is, but we have to ask ourselves why preservation of a good, for example, like non-use, someone else's non-use is not a form of consumption. Why that's not a way in which you consume a good. If I give you a gift, am I not consuming the good in a way, even though I want you to use it? You want you to use it. Is that not, in some sense, a form of consumption on my part? Although I'm relinquishing it.
You're gifting me ideas right now, and the marginal cost for everyone in this room to use all of the ideas you just gifted to me remains zero.
I'm sure lots of people want me to shut up.